I am the director for the Catholic Commission for Summit County. I work for Catholic Charities in the Social Action Office, and my office is actually in Akron. What I'd like to do tonight is start off with a prayer, and we're going to go ahead and have Judy start, and then we'll get the program started. We're only about 10 minutes behind, so that's not too bad.
This is from the Gospel of Luke. Now 2 others, both criminals, were led away with him to be executed. When they came to the place called the Skull, they crucified him and the criminals there, one on his right, the other on his left. Then Jesus said, "Father, forgive them. They know not what they do." And they divided his garments by casting lots.
God of compassion, you let your rain fall on the just and unjust. Expand and deepen our hearts so that we may love as you love, even those among us who have caused the greatest pain by taking life. For there is in our land a great cry for vengeance as we fill up death rows and kill the killers in the name of justice, in the name of peace. Jesus, our brother, you suffered execution at the hands of the state, but you did not let hatred overcome you. Help us reach out to victims of violence so that our enduring love may help them heal. Holy Spirit of God, you strengthen us in the struggle for justice. Help us to work tirelessly for the abolition of state-sanctioned death and to renew our society in its very heart so that violence will be no more. Amen.
Amen.
This is a collaboration that we have with the Ohioans to Stop Executions and the Catholic Commission of Summit County. And we have Judge John Russo and Judge Michael Donnelly who are here tonight to talk about the joint task force on the death penalty recommendations. And they will let them introduce themselves and tell you a little bit more about the task force. Thank you.
Diane, could we just mention that State Representative Christina Rogner is here
I'm
with
sorry,
us this
yes.
evening?
Christine Rogner.
Hi, just very briefly, I'm Christina Rogner. I'm your state representative if you live anywhere around Stow, here in Northeast Summit County. I'm in my 3rd term in the Ohio State House in the legislature, and I've always been very much pro-life, particularly when it comes to the issues of the unborn. But before, when I first joined the legislature, I was really for capital punishment. You know, if you were convicted, that's it. You know. But over my time there, for the last 5 years, I told Judy in the library when we talked this week that I don't know if God has softened my heart and opened my eyes, but certainly my position on that is changing, and I'm here to learn more, and I'm very anxious to hear what the judges have to say. So thank you all for having me here.
Thank you.
And we also have with us too tonight, I'm sorry, I spaced on that one, but we have Abe, forgot your last name. Bonowitz, so yes, and he is here from the Ohioans to Stop Executions as well. So with that, I will turn it over to the judges. Thank you.
Good evening, everyone.
Good evening.
I'm Judge Mike Donnelly.
Hi, good afternoon or good evening. I'm Judge John Russo. We'll get a chance to introduce ourselves. I'll let Judge Donnelly.
It's an honor to be here tonight, and I want to thank everyone for the invitation, and it's an honor to have one of our state representatives here as well. It's nice to meet you, and look forward to engaging in this dialogue with you. Just to give you a little bit of background information, I've been on the Cuyahoga County Common Pleas bench. I was first elected in 2005. I started my career in 1992 with Cuyahoga County Prosecutor, then Cuyahoga County Prosecutor, the late Stephanie Tubbs Jones. And I served as a prosecutor for 5 years in the General Felony Division. And then after that, I went into civil practice. I practiced for 6 years in the civil realm, both on the defense and the plaintiff side of the business. And then 12 years into my legal career, a spot on the Common Pleas bench opened up. Judge Griffin, longtime judge, had reached the age of retirement, so that's a position I'd always sought. My father was a longtime probate judge in Cuyahoga County, and I had always aspired to run for the bench. So in 2004, when that spot became open, I joined my colleague, who was also practicing at the time, John Russo, who ran at the same time, and we've been serving ever since. We're both nearing the end of our second term, when we will run again in 2016. We were unopposed, fortunately, in the last, or fortunately in the last, fortunately, and hopefully it'll go that way again. John, you tell a little bit about your background.
Okay. Well, again, as Judge Donnelly said, we had an opportunity to run for office. Judge Donnelly and I both come from, we kid each other. He comes from the Jesuit upbringing at St. Ignatius High School, and I have the Holy Cross upbringing from St. Edward High School. And so we always kid each other. Of course, his dad went to St. Edward High School. I have to kid him. And I went to John Carroll University. So I like to say I'm a well-rounded, raised and taught by both the Jesuits and the Brothers of Holy Cross. So when Mike and I did run for office, let's say that a friendship forged that I will say to you will probably never fade. We knew each other socially more than anything before that. A few years older than him, but socially became more than just that. So not only are we colleagues on the bench for going on our 11th year, but we're also very good friends. He and his wife and his family are dear to us and my family as well. When we both took the bench, the court in Cuyahoga County, so you have some idea, is a pretty large bench, 34 judges that oversee our county. And the bench itself, since we've been on it, has taken on a different feel. We are more active in the what we believe to be a public service and giving back to those who have elected us in Cuyahoga County. So it's not a strange environment to be talking to you, because we do it very often, whether it's to community groups or whether it's to lawyers. Judge Donnelly and I are out very often. When we had the opportunity, well, I'll tell you a little bit about how the opportunity happened. Is being on the bench, we both became very active and involved in our associations in Ohio. So there's the Ohio Judicial Conference, and there's also the Ohio Common Pleas Association of Judges. And that's all of the judges in Ohio that we meet and continue to collaborate on different ideas. I sit on the Ohio Judicial Conference chairperson as a committee, and I was asked by our Supreme Court Justice at the time whether I would be interested in sitting on the task force for the death penalty task force. At the time, I wasn't quite sure why the chief had sought me out. I knew her, but I also, being involved down in some of the conferences, I wasn't quite sure. And when I asked her why she reached out to me, she said to me, well, you've been a judge for, at that time, 7 years, and you have handled 6 capital murder cases where the death penalty could have been handed down in those 6 cases, which was a shock to her that someone just taking the bench in 7 years had 6 capital murder cases. I then went to my colleague at the time and said, that the chief had reached out to me, and I said I knew that Judge Donnelly was compiling some statistics about the death penalty and some of the concerns that he had sitting as a jurist. And so I mentioned it to Judge Donnelly, and he reached out and said to the chief as well, if you're interested in having me, I also have this interest. And so the two of us then were asked to collaborate on the death penalty task force. So that's how we find ourselves before you. And what we want to do is share with you our experience over the 3 years of the death penalty task force, what each of us did and what subcommittees we sat on, and then some thoughts about Cuyahoga County and a little bit of where we've moved, some of the involvement that Judge Donnelly and I got involved with Mr. Keith and his brother. We'll share a little bit of that situation with you as well. So I thank you for having us. We'll get an opportunity. If you didn't have, there's a couple handouts. If you didn't get it, we try to pass them out. A couple handouts that we'll probably share with you as well. But I thank you for having us. All I'll say is, look, we're not in our county. right? So we're not looking for any votes. But I think it shows you that the importance of the task force and what it meant to us, and making sure that there's an opportunity that we on the task force are out speaking about it, so others can then get a little energy and see if they can move some of the recommendations. As judges, we can't do that, so we can't be out making points and trying to push agendas. And so all we wanted to do is share with you our experience on the task force, and so we thank you for having us. Judge Donnelly's going to speak first, a little bit about his experience, and then I'll speak about mine, and then see if there's a chance that we can answer questions for everybody as well. So again, thanks for having us.
Thanks, John. And I'm glad Judge Russo mentioned that. It's very important as judges that you understand our roles when we come out. We will answer and accept any invitation from any group to speak about our knowledge about not only the task force, but about our experience as jurists. As jurists, we take an oath. We cannot go out and advocate for the abolition or the implementation of any type of laws. When we take our oath of office, we take an oath to follow the law as it's been handed down by our General Assembly and the higher appellate courts of this land, and we take that oath very seriously. But we also understand the reality that as judges, we're on the front lines, that we observe how laws that are implemented and are supposed to apply to everyone in the state of Ohio equally are applied. And everything I'm about to tell you, everything that Judge Russo is about to tell you, is based on facts. Facts that you can take and spread the word and let other people know what's taking place as it relates to the death penalty and how it's applied in the state of Ohio. And I remember when we were first appointed, and I received the call from the Chief Justice, and she said she was going to appoint me. I missed the first meeting. I went down with Judge Russo, and I remember driving back from Columbus and saying to him, you know, this is such an important task force, and if anything is accomplished, if anything, the most important thing that this task force can accomplish is to inform the citizens of the state of Ohio what is really taking place with regards to the death penalty, how it's administered, because I don't believe the vast majority of citizens understand that. And I was interested in the representative's remarks, how your feelings have evolved, and that's similar to mine as well. I started my career as a county prosecutor. In law school, I used to go down and watch murder trials and rape trials take place, and nothing more did I want to do than to take place and be part of that seeking of justice, holding criminals accountable for their behavior, protecting the community. That's why I wanted to become a prosecutor. So when I started my career, I really didn't have strong feelings against the death penalty. When you're a prosecutor, and I have the utmost respect for the prosecutors in the state of Ohio that do that day in and day out, going after truly horrible criminal behavior. I used to think that every now and then when I reach the zenith of what I encounter as what I think is the highest level of human depravity, or on how badly human beings can treat other people in murderous situations, and I can't be shocked anymore, then suddenly something happens that shocks me to the core again. And it's easy to see why prosecutors buy into the concept that some crimes that occur in our state are just so horrendous, and that any term less than the implementation of the death penalty doesn't meet the goals of justice. But my feelings changed once I was elected into Cuyahoga County, into the judgeship, and then I was, for the very first time, faced with the opportunity that I would at one time in my career, have to impose the death penalty on someone else. And I want to tell you about that experience and how my feelings began to change. When I first was elected in 2005, I had a death penalty case scheduled for trial nearly 1 month after I took office. Much of the discovery had taken place, was set for trial, and to be honest, I was scared to death about having that being one of my first trials. Fortunately, what happened was there was still some issues between the parties about whether certain information had been turned over, and as a result of a number of hearings we held, we kicked the trial into October. I have a very experienced bailiff. I kind of stole him from Judge Suster, a senior judge, and when I had known his bailiff for, we'd become many friends many years in advance, and I told him, you know, if I get onto this bench, I'm going to ask Judge Suster if I could hire you. And I don't think Judge Suster's forgiven me, but John's a younger guy who's starting a family, and Judge Suster was reaching the end of his career, and John fortunately came up with me. So he was very experienced, and as we talked about this case, John said he was quite sure that this was not going to go forward and had no real chances of ending up in a death penalty. He thought it was he didn't know much about the facts. It was a robbery gone bad. So we put it out in October. As as we approached, it became clear that this case was not going to work out. It was going to go to trial. So my bailiff's description of the case that he did not feel would ever end up into a death penalty turned out just to be the opposite. And we proceeded to trial, and this was probably some of the most horrible facts that I've ever encountered. It involved a young man, 17 years old, who spent Saturday afternoon working with his father. His father had bought him a new car when he was 16, and they put some spinners on the car. The young folks like to drive around and makes the car look cool, and he was very proud of it, and asked his father if he could have permission to take it out, show it off to his friends. He was down here actually in the Akron area. He went to a club. He ended up running into someone that he had worked with at a restaurant, and he was in the company of two individuals with very serious criminal records, robbery, armed robbery. They ended up going from the club to a party, and somewhere in the minds of the two defendants that were with him, it came up that they wanted that car and they wanted those wheels, and they were going to take that by gunpoint. And then it wasn't enough to just take the car. One of the individuals was claimed to have said, "This individual knows you. If we take the car, it will only be a matter of time before we're identified." And so what they decided to do, they put this young man in the back trunk of the car, and alive, and they transported him all the way back to Cuyahoga County to an area town where there's a number of fields, East 83rd and Rawling. And the defendant that was assigned to my room for trial after he entered a plea of not guilty opened up the trunk and proceeded to shoot this young man 7 times in his stomach as he pleaded for him not to. He was then pulled from the car, and another defendant who was with him used a hammer to finish off the job. This was very hard testimony to sit as a judge. It was devastating for the victim's family to sit in the back of the courtroom and listen to the last moments of their child's life. And it was so strong that the father was crying so much that I had to have my bailiff go back and respectfully ask him to step out of the room, because I didn't want anything that was happening to taint the jury's ability to listen to the evidence. So he was respectfully, he understood, and we proceeded with the trial. And at the end, the way a death penalty case works in Ohio, you have the guilt phase, And there are certain specifications that need to be proven by the state beyond a reasonable doubt. And if they're proven, then that means that a second hearing is warranted, in which that same jury will hear arguments from the state on aggravating factors that exist, recognized legal aggravating factors, and mitigating factors. And they're asked to perform an analysis of that. And if they find, after they perform that analysis, that the aggravating factors outweigh the mitigating factors, then they're directed by the law to recommend a death sentence. If they don't, or they can move on in their deliberations and decide upon a lesser sentence. So the night the guilty verdict, I still remember, it was early December, was delivered. The jury was excused, and I spoke with the attorneys, and they both wanted to put the mitigation phase after the holidays. So we set it January 1st, right after the holidays took place. And I remember walking back into my chambers that night. It was probably about 7:30, and I sat in my chair, and I said, this is going to be a death penalty recommendation. That was the reality of the first time. We had campaigned, Judge Russo and I, and we've been asked about that. And as a campaigner, you say, well, I follow the law, and that's what. But when you're actually put in that place, I can tell you, it's not a place you want to be when you think about the gravity of what's being asked about you, or what may be asked. So interesting what took place the next week in another judge's courtroom in my courthouse. The individual who was alleged to have used the hammer on the victim was set for trial as well. And I fully expected that to go to trial, just as mine did. That defendant hadn't cooperated in the prosecution in my case. He was just waiting there, remaining trial, different lawyers, and out of coincidence, his trial was set the following week. I went on to my business of tending to other cases, and then we came up to the mitigation phase, and to my shock, I overheard that the prosecution in that case had decided to offer a plea bargain to the individual in which the death penalty specification was taken off the table, and he was given an opportunity to plead to an offense in which he was sentenced to 45 years to life in prison. And the defendant took the plea, and that case was resolved. So then, the first week in January, I was all set to conduct the mitigation phase, in which the state was going to be going before this very same jury that found them guilty, and they were going to ask for a recommendation for the death sentence. They filed what's known as a motion in limine, the prosecution did, the week before the hearing. And the motion stated clearly that they had entered a plea against the individual in the other room. This was known. They did not want the defense lawyers in that case to let this jury know that that had taken place. And we came in, and there was no brief in opposition from the defense, and we held a hearing, and at that particular time, the law really wasn't clear on whether that should should come in or not. The prosecutors strongly, they had some case law on that said, look, that's a separate trial. It's not relevant to this proceeding. And the defense lawyers said, well, how can it not come in as a mitigating factor? And so I took a recess. I spoke with some senior judges that I respect their opinion, and did some soul searching, searched the case law. There was some dicta, which means some lines in some Supreme Court cases that suggested that it should come in. And basically after having some discussions, it just hit me that that's just not fair. That is not fair. That if you're going to allow someone who was equally culpable, if not arguably more culpable, of this horrendous crime, to spare his life. And this was done on the signature of some supervisor down in the office. No reasoning stated. It was a prosecutor supervisor who heard the case and said, this person's going to live, you go proceed and argue for death in the other. And I made a decision that the state would be, overruling the state, and that the defense would be allowed to bring that fact in. A decision that made the papers, that I ruled against the state and dealt them a low blow on this motion, and defense lawyers were able to argue that fact. To be honest, this crime was so horrible that I didn't know if that would even make a difference. But we had a very fair-minded jury, and after 2 days of deliberation, they came back and they entered a recommendation for life without parole. Very cold-hearted defendant, terrible upbringing. You know, when you learn about the upbringings of some of the defendants, you understand a little bit more where they got to where they were. But he was so angry that he ended up delivering an obscene gesture to the family members in the jury, or in the back of the courtroom, the victim's family. He told me, I'm not going to repeat it here, that's not for here, but he told me something, and he went off after that he was sentenced to life without parole. But I remember the radio announcers that night were on the news condemning the jury, calling them stupid, saying that, you know, how could they not put this individual to death? And it's terrible. But that's the first event that started getting me to think about whether whether the justice system is even capable of, you know, justice system can do a lot of great things. It can find people, it can protect society, it can exonerate the wrongfully convicted if everyone's doing their job right. Deciding whether individuals should die in a fair manner, I believe, is just beyond its ability, capabilities of the justice system. And that was my feeling after that trial, and I started, as Judge Russo mentioned, studying what took place in death penalty cases. I never tried another one. Every death penalty case that was assigned after that particular experience resolved in a case coming right up to the verge of trial, and the prosecutors would, in exchange for the defendant's plea of guilty, would remove the death penalty specifications and resolve the case in that manner. So when I started to see this take place, not only in my courtroom, but in other courtrooms throughout, I began to wonder, how often does that happen, and why does it happen? As judges, we were quite aware of the expense of these trials, and so I wanted to find out more about Cuyahoga County and what was taking place with all these death penalty prosecutions. When we as judges finish a death penalty, we have to fill out forms about what happened. Did they go to trial? Did it result in a death sentence? Did it result in a plea agreement? And we send it down to the Supreme Court. This is a mandatory form that has to be filled out. So it got me thinking. I called down to the Supreme Court and I said, you know, what happens to all that information? What do you do with it? Do you compile it into some type of spreadsheet that we can analyze? And to my surprise, they said, you know, we don't do anything with it. You know, the state public defender's office is interested in it. They'll come over from time to time and they'll get it. So I called the state public defender's office and I said, do you have information on death penalty in Cuyahoga County? And they said, we have tons of it. Excel spreadsheet, what do you need? And I said, well, I want to see, you know, how many have been indicted, how many of them result in death sentences, and how many result in plea agreements. And when they said how long a period do you want? I said about 10 years. And that's what you have on your desks right now. These are the facts about what took place in Cuyahoga County. And you know, this, we got cases dating back to 2000. All of these individuals on these sheets came from the records of the State Public Defender's Office. All of these defendants were alleged to have committed a murder, and the state of Ohio had assessed that case, gone before the grand jury, and decided that this was a death penalty worthy case, and that because of this case, the facts of the case, it should result in a death sentence. To my shock, what I discovered is over a period of nearly 10 years, in all of these cases that went to a jury verdict, there were only 4 cases that resulted in death sentence by a jury. Many of these cases, as you'll see in the middle of the column, anywhere where it says yes, they ended up in a plea agreement. Generally, right before trial, they would say to the defendant, "You want to resolve this case? Here's the deal. We're going to take the death penalty specifications off the table in exchange for your plea of guilt, and the case will be resolved." Sometimes they'd have agreed sentences, sometimes they'd leave it up to the court. Now, if you talk to most people, even proponents of the death penalty, you would think that their main argument that would be that, well, the death penalty should be enforced because it is used against the worst of the worst. I'm here to tell you, as someone on the front line, that is the farthest thing from the truth, and it's something that can be proven with facts. The death penalty in Ohio doesn't depend on the facts of the case. It doesn't how heinous the case is. It depends on where you are when it's committed. If you're in Cuyahoga County, where they have the resources to fund the death penalty, that includes hundreds of thousands of dollars in legal fees, court time, experts, court costs, staggering. You can have a list like this that accumulates into that many indictments, and even though it results in just 4 death sentences over 4 years, there was no questioning of it. If you look at any of the other counties in Ohio, very few, especially in the more rural counties, and we mentioned this in our discussions at the task force. There was a crime that occurred a number of years ago. Some of you might be aware of it. Horrendous triple murder in Knox County, when a woman, her friend, her 5-year-old boy, brutally murdered. If you heard the facts of this particular case, you wouldn't go to sleep tonight. It's that bad. That individual in Knox County, where presumably they don't have the resource in Cuyahoga County to fund a death penalty sentence, was offered a plea. The prosecutor purportedly indicated that that's what the victims wanted. And got to keep in mind, in criminal prosecutions, even though the victims are very important to the state's case, the state of Ohio does not represent the victim. They represent all of us, the state of Ohio. And if any crime that I've heard of would amount to one of the worst, this certainly fit the bill as something that would be considered. That individual was pled to a life without parole within a matter of days. And in exchange, he provided information as to where the bodies were. But very troubling. And as I saw through these results of these prosecutions, you're going to see someone, as I mentioned, thought that this case was worthy of a death penalty sentence, proceeded to trial, proceeded at the indictment, went all the way up to trial in all of these cases where it says plea, withdrew specification. And what type of results did the state obtain? Are they all long 45 to life sentences? No. Look at them. And some are up in the 20s, 30s, but then you have 8 years, 6 years, 10 years, 2 years. Judge Russo actually has defendants on his docket where they started out as a death penalty case, and after it proceeded to go to trial, they ended up with probation. So this was really troubling, and this for the long time was the culture in Cuyahoga County. And you know, the defense bar wasn't raising their arms about this. Defense, when a death penalty case was indicted, they were generally the highest paid assigned counsel. Generally, most criminal defendants charged with the death penalty are indigent and need to be afforded counsel. So they would be appointed, and these were prized assignments in Cuyahoga County when a death penalty case came up, because you were going to get paid the highest fee, and you also get to choose an expert that would deliver, presumably at the death penalty phase of mitigation. They would do all sorts of research on the background of the defendant, so if it ever got to the mitigation phase, they could deliver that testimony during the course of the trial. And so a whole cottage industry of experts developed in Cuyahoga County. And it was so alarming that right around the time that Justice Paul Pfeiffer had made the news, and he made the news because it's not often that a Supreme Court justice speaks out about an issue like this, but he spoke up and told his feelings about the death penalty. And it generated a firestorm of debate between prosecutors and proponents. And there was a number of letters written to the editor of the Cleveland Plain Dealer concerning the death penalty that I was following, having analyzed all these statistics. And there was one, an anti-death penalty case, and then one came in from the Ohio Prosecuting Attorneys Association. But something struck me about that particular letter to the editor, and this is, which made me want to write my own letter into the Plain Dealer. And in the prosecutor's letter to the editorial, they indicated that Justice Pfeiffer was wrong in taking the position that he did, and they believe that the death penalty is being applied exactly to those kind of offenders whom most people agree it should apply to. They concluded by stating, perhaps we should first be clear what the process is now and what is happening under current law. And that struck me, and I went to what I said to my colleague and friend Judge Russo. This is what needs to be told to the citizens of the state of Ohio. What is happening? And I couldn't agree more. So I wrote this letter, and I'm going to read it to you right now. I wrote it, and I had this discussion with one of the editorial board. And I stated in this letter, my own concerns on this issue arose after I mentioned the prosecutor's letter and what it stated. I said, my own concerns on this issue arose at a pretrial during my first term as judge. A case was assigned to my docket in which 3 defendants were charged with aggravated murder with death penalty specifications. Each defendant was accordingly assigned 2 attorneys paid for at the taxpayer's expense. Each side intended to file a multitude of standard motions and requests for expert appointments involving even more expense. The attorneys in capital cases are all highly qualified and professional. This is true. I could not help, however, but observe the lighthearted, even jovial nature in which the adverse parties engaged each other at the first hearing. And what is wrong with this picture, I thought to myself. Granted, this is only the first trial, but the state has decided that each defendant in this case should pay for their alleged crimes with their lives. Should not this fact alone demand a certain tone of solemnity? That's when it struck me. No one in the room honestly expected the case would actually result in a death sentence. The attorneys could hardly be blamed for this mindset. According to the statistics collected by the Ohio Supreme Court, a Cuyahoga County grand jury has issued 367 death penalty indictments in the last decade, compared to 181 in Franklin County and 53 in Hamilton County. Out of all these cases, only 3, and now since then one other has resulted, out of all these cases, only 3 have resulted in death sentence after a jury trial. The last death sentence recommended by a jury in the county occurred in 2007, at the time of this letter, February 2011. The state has the discretion on whether to pursue a death sentence when the law dictates it may apply. Death penalty cases by their nature are inherently more expensive than murder cases where that sentence is not pursued. 2 pre-qualified attorneys must be appointed to represent the accused, the vast majority of whom cannot afford an attorney. A cottage industry of experts exists to compile loads of data about the defendant which may or may not be presented at a mitigation hearing should the state obtain a conviction. Death penalty trials can tie up the court's time for 3 weeks or more at the expense of other cases. Appeal costs are immense and the litigation can last well over a decade. Reviewing the remaining Cuyahoga County cases that did not result in a death Reviewing the remaining Cuyahoga County cases that did not result in a death sentence reveals that a great many cases were resolved through the plea bargain process. In a plea bargain, the state will agree to dismiss the death penalty specifications in exchange for a plea of guilt on an underlying or amended charge. The convictions obtained through this process range from aggravated murder down to involuntary manslaughter. The sentences issued on these cases that began as death penalty cases are widely disparate, ranging from life without parole to less than 5 years, even probation. Setting aside for the moment the question of whether the same results would have been achieved outside the context of a death penalty case, a broader policy question arises. I return to the prosecutor's assertion that the death penalty occurred under current law is being applied as intended. Reviewing the statistics, the question needs to be asked. Is the ultimate punishment being reserved for those cases that shock the collective conscience of our society? Or is it simply being used as a bargaining chip in a judicial process at an enormous price to the tax-paying citizen? So I wrote this letter, and I put all the statistics in, and I drove down, and I took a deep breath, and I walked into the plain dealer, and I thought, man, this is going to cause a firestorm of debate. And that's what I wanted. I wanted to create some dialogue. And I received a call from the editor, and he said, you know, we published one anti-death penalty case letter, and then it drew a proponent, and we just decided we want to move on to a different area. And now that same editor now works for our prosecutor's office as the information director. But shocking to me. It could be because what these statistics reveal, whether you're a proponent or an opponent, no one would ever argue that this is a proper method on how a death penalty case should be applied in Ohio. So about that time, that's when I learned afterwards that the formation of the task force, and I asked the Chief Justice to see if she would appoint me, and I was greatly honored that she did. And we went through the process, and we went very serious-minded individuals. I was proud to serve with all of them, the prosecutors, the defenders, the academics. We have Professor. Yeah, well, you were always there. You were always present and participated and provided great information. And we had some great discussions about the reality of what's taking place. And our task was, can the death penalty process, is it fair, number one, and can it be improved? It would improve the process by making it more transparent. I was on a judicial committee of very thoughtful judges. Am I running out of time?
little bit.
Okay,
That's-
I'm moving.
He felt me stand up.
All right, okay. And, you know, Kate, we came up with some great recommendations. I'm going to tell you about those, and then I'm going to turn it over to my counsel, Judge Russo. What should be implemented as a result of the task force right now, tomorrow, and I think everybody agreed with this on my committee. It was headed by Judge Sullivan, very thoughtful senior judge, and what we came up with was a recommendation that if a death penalty proceeding is going to take place in the state of Ohio, absolutely mandatory, every aspect of that proceeding has to be on the record. There should never, ever be any backroom pretrial discussions between the judge, the prosecutor, and the defense counsel about anything. From day one, there should be pretrials, frequent pretrials on the record in the courtroom where the public, the press can be present, and every aspect of that case goes down on the court reporter's record. Number one, the prosecutor is required to stand up and put his ticket on the line, basically, his ticket to practice law, by stating, I have turned over every piece of information I intend to use, and I have also complied with my obligations under Brady and turned over every bit of exculpatory information that I'm aware of. That has to go on the record. Defense counsel has to be equally questioned by the court and asked what they have done to prepare the case. This protects both sides in the adversary system. Prosecutors complain of frivolous, after convictions, frivolous motions about inefficient counsel. This type of record would protect the state against concerns that they have. Also, if a defendant in a death penalty case asks for an expert and wants an expert to analyze any aspect, but does not want to tip his hand to the state before finding out what that expert's opinions are in the particular case, the defendant can go before a court in an ex parte hearing, on the record, prosecutors out of the room, but the court reporter's there, articulate their request for an expert, why they want it, to the judge, and if the judge agrees, then it's appointed. That piece of the record's placed under seal, so no one sees it until after the case is over with. If the judge denies that request for an expert, the parties have an automatic right to take that over to the Court of Appeals and have a three-judge panel look at it, so that that if they decide the trial judge is wrong in not granting the funds for an expert, then they'd have that automatic right for appeal. Two very strong improvements that could be made tomorrow. Judge Russo and I, our main concern is that the issues on this task force are going to find their way into some file folder and start gathering dust. We can't let that happen. There's a lot of thoughtful recommendations that can be made in there. But again, what you have before you as advocates that we provided you and what you can obtain further are statistics to demonstrate how it's really being applied. And it is not being applied against the worst of the worst. Yeah.
Who's the ones that have to implement this? Is this a legislative thing?
There are some legislative recommendations, that statutory recommendations. Some have to be formulated at the court rules committee, but ultimately approved by the legislature as well. So. All right.
All right, sure. All right, so I'll just I'll make a few comments, and then we'll see if we can answer some questions between both Judge Donnelly and myself. I mentioned to you 6 cases relatively quickly in 6 years or 7 years on the bench. I became what they called the resident expert judge in handling death penalty cases, because when I got my first death penalty case, I'm a little bit of a A-type personality, and so I created binders and folders, because the main concern that Judge Donnelly and I are taught as judges is death is different. And because there's a death penalty in Ohio, we treated cases, and we were taught and trained as judges that when we handled a death penalty case, we should handle it differently, because we have someone's life at stake. So when we went down to judges training class, we were taught death is different. So it resonated with me when I had my first case, And so I methodically took my case. I created journals and books. I made sure that I was at every turn, making sure that I was looking to that individual who was accused, who stood to have his life taken from him, to make sure I was protecting his life and making sure that I was following the rules according to the law. And what I began to gather was a way of handling a death penalty case. I was getting them frequently. And for me as a new judge on the bench, I didn't think, I thought every other judge in the state of Ohio was having the same situation, a lot of death penalty cases. And I began to ask my colleagues, well, you know, some of the older judges, how many death penalties have you had? To this one judge, and he said, well, I've been on the bench 22 years, I've had one. And I said, well, I'm on my third, I'm on my fourth. So, and I began to ask questions around the state of Ohio to all the judges. As I told you, we would visit down in Columbus, and then I began to realize that not only is death different, and we should be looking at it that way as a judge, death was different in Cuyahoga County. And very different that you see the stats here. I look down and I recognize all of my names, Reginald Clement, Samuel Reed. If you go to the very last page, this is the one Judge Donnelly speaking of. If you look at the last case, or the second last case, there's defendants, when you see the letter A, B, C, D, E, F, G, all of them are my case. All of them were charged with the death penalty. Because of a murder. And all of them came into my court with the death penalty specification. As the judge mentioned, it means that the state is going to proceed. Somebody looked at all of these defendants on one case and said all of them should get the death penalty. Now, what I had learned as I was getting wiser as a judge, into my years of experience, that the process was more likely being used as a tool to get a plea bargain, as opposed to an actual worst of the worst case, where the death penalty, as the judge said in the factual notation in Noble County, was it Knox County, we wouldn't want to tell you about that case. And if you read about it, you probably wouldn't sleep tonight. And maybe that is the worst of the worst. But this case was not the worst of the worst case. And if you actually look at it, not one of them went to trial. The yes that appears in the column means they all took a plea bargain. And yes, I put 3 of them on probation. When you see, or 4 of them on probation, 3 years of community control sanction, that means probation. So 4 of those, of the 7, were on probation. The others accepted some responsibility. At some point I gave them life without parole or life with parole. So LWP at the end means life with parole. They would have to serve the 28 years before they would be eligible for parole. So Judge Donnelly's correct. What became apparent to us is that something was wrong with the way the death penalty was handled in the state of Ohio. When the chief came to us, she didn't say, our charge wasn't, hey, should we do away with the death penalty? So understand that. We were not charged with, should the death penalty be turned away or nullified. We were charged with, look at the death penalty as it sits today, and are there ways to make it fairer, to make sure it's equal throughout the state of Ohio, so that if it was handed down, it would be handed down equally in any jurisdiction. And when we got to the table for the 2.5 years before we began to write the report, we realized it was not equally distributed and handled by prosecutors throughout the state of Ohio. And then you say, is that fair? Should it be fair that the death penalty is used as a plea bargain tool? Is it fair that in some counties you get to because of the economics, you don't get the death penalty charge, and so forth? Now, what I also became aware of as a judge is, if you understand, I have a docket. So I have cases that represent criminal cases and civil cases. That docket that I took over 11 years ago was another judge's docket until that time it was created. So if you take my case that are on my docket, even though they've been completed by another judge, some of those cases may come back to me as a judge through what's called an appeal process, or a motion for a new trial when new evidence is found. What I also found is a case of mine where someone was sitting on death row, 2 cases that I actually had where evidence was excluded by the prosecutor in the defense of the individual. They were not provided the information. So the prosecutor, and I'm not saying, I agree with Judge Donnelly, we have wonderful advocates here in the state of Ohio, both for the state and the prosecutorial role and as public defenders. But in this case, in these 2 cases I had, there was this pattern of withholding evidence against individuals that were sitting on death row. One such that I, set that individual free 2 years ago. I received criticism from all over, not only here in the state, but outside the state of Ohio. And my ruling was such not that I acquitted Mr. Keenan of his charges, but I found that the prosecutor had created such misconduct that he would never be able to receive a fair trial. And that being said, that case is currently being deliberated by the Supreme Court to decide if I was wrong. And I'll know the result of that, I think, sometime in April or May of this year, whether the Supreme Court agreed with me or not. A second case I had that came back because of prosecutorial misconduct, the state of Ohio agreed with the defense. Actually, the defense filed it for a new trial, and the state argued against it. And it was an old case. The gentleman had already served about 28 years in prison. And when I began to look at the allegations of new evidence, I did in fact believe that there had been some evidence that had been excluded, and I held a hearing. And witnesses came in to testify about what they would have testified to, but were told by the prosecutor they weren't needed and get lost. And that evidence brought such a mindset to both me and even the prosecutor that they allowed that case to be terminated, but after 28 years of that defendant serving time. That was a unique case too, because the defendant was not, he got deported. So as soon as he left our jurisdiction, he went to Jamaica, where he was a citizen. Those are concerning, right? And as a judge, what we see that comes through, we're looking, you say the word, justice system. We have a justice system here in the United States, which I'll tell you is the best justice system in any country. And I've done a lot of studying. I've had Libya judges come here and shadow and play a part. I've had Kosovo judges come here. I've had a lot of interaction with other countries and how their justice system works. But what I would say is we have to be careful and looking at our justice system, make sure that it doesn't turn into, if you say it slowly, just a system. And if it becomes just a system, then we need to be able to advocate for a justice system, not just a system. And so that being said, I'll say just briefly, I mentioned Mr. Keith in the back. Mr. Keith, at our first opportunity where Judge Donnelly and I have been asked to go around Ohio to speak if there are those like yourselves who are interested. And so we'll get in the car and travel from Cuyahoga County like we did tonight to come here because we believe it's something that should be discussed, because there should be some advocacy from those of you who are here, we hope, to move this forward. To answer the gentleman's question, who sat on our task force? And I made this copy for you. It's very small. If you actually go to the actual report, it contains a lot more than this, and you can go to the Supreme Court website and actually look at the report. But what I just wanted to give you is who sat on the task force. That's page 2. And you'll see there's a round number of individuals. There's prosecutors, there's public defenders, there's private lawyers, there's professors from around Ohio, there's judges, there's sheriff's association, and there's legislators. So Senator Seitz was a huge advocate on this committee. He is taking up a lot of what we would hope would be legislation at the state level. And whether it's going to gain traction or ground, I'm not sure. He's really taken up a lot on the mental health, those who are mentally ill, and whether they should be executed or not. So I gave you the page just so you know who served on it. And then you'll see the next pages, there's 56 recommendations. It'll show you the vote total. The majority of them are unanimous, or there's only 2 or 3 that would vote no. Some are very close. But these are what came into place. 56 recommendations came out of our task force. There is a dissenting report, and that's, I didn't purposely leave it out, but there is a dissenting report, a long dissenting report from the prosecutors that's contained in the report if you went online and took a look at it as well. So, this is where we came from. I'll tell you the experience was I think the experience of the debate that happened in those doors and in those rooms was good. It was good for the topic itself. A lot came out of it. And I think what Judge Donnelly and I hope is that it doesn't end here, that it just doesn't, I think it's starting to gather some dust already. And so that may be where it ends up. There was a similar task force in 1972.
Actually, the
ABA task force.
The ABA task force was in 2007. The Ohio State Bar Association did
Was in
something in 97.
97.
Yeah.
There was actually an older one in the 70s.
You're right, that was a deterrence study.
Right, a deterrence study that looked at this. The only reason I bring that up is my uncle was on that, who was a state senator, or House of Representative, Tony Russo. And so I found it, when I went back and started to research some of that, I found that unique that my uncle was on that as well. Here's what I would say is, I work specifically with assignment of counsel and how can we improve the qualification of those who sit and represent those who are charged with the death penalty. How can we improve the process of judges having an opportunity to make sure the education is there for those individuals? How do we have expert reports available, and who do we qualify as experts? So some of that you'll find in here and out of my subcommittee. What we did in our first conversation that we had, Judge Donnelly and I, we met the gentleman in the back, Mr. Keith. His brother was on death row. 13 days from execution. And what happened is, in their case, is similar, that there's evidence that did not come forth during the trial in Bucyrus County, such that Judge Donnelly and I became acquainted with the case, and we actually had an opportunity to meet Mr. Keith. He came to my office and had a chance to share a lot about his brother's case. Not being advocates for him or against him, we found at least compelling. There was evidence that maybe, I won't say that was maybe, evidence that was not used or turned over to lawyers. There may even have been bad lawyering and a number of things that his brother's case shown.
And the fact you should know about that case, if you're not familiar with Mr. Keith's brother's case, Kevin Keith, came within 13 days of the death penalty. And the facts of that case, first of all, the trial would never have taken place under the standards that exist now. It went from date of crime in February to Mr. Keith convicted based solely on eyewitness testimony, which has been called into deep question, and to Mr. Keith being on death row by May of that same year. Never. Not with any type of certified defense counsel. Now, this case, he came within 13 days of receiving the death penalty. And at the time, it garnered national attention on the case because of the facts that have been developed over the years that many people believe question the doubt of the accuracy or the truthfulness of the verdict. And the parole board, Mr. Keith was given the option to argue for a lesser sentence before the parole board 13 days before his execution. He would not allow his attorneys to ask for that. He said, I want a full pardon. He's maintained his innocence from day one, or I want to be executed. The parole board recommended execution. Governor Strickland at the time reviewed the case. He was so troubled by what he perceived as the doubt in the case that he commuted the sentence in an election year to life without parole, with indications that it would be revisited at some point.
For clemency.
for clemency. Unfortunately, Governor Strickland lost that election, and Mr. Keith remains in prison. The media spotlight has gone from the case, and you ask yourself, if evidence is so strong that the governor of the state of Ohio is willing to overturn a court order to carry out an execution, thank God the death penalty didn't proceed. But are we comfortable with a man serving a life without parole based on the same level of evidence?
Yeah, so we will tell you that we weren't comfortable with that. And again, judicially, what involvement we can get involved in with Mr. Keith is, but what we did do is ask Mr. Keith if he would be interested if we found pro bono counsel, that would be a lawyer who would give their time without having to be paid for his or her time. And we know two lawyers in Ohio or in Cuyahoga County who have the ability to handle death penalty cases. And we went to their law firm and asked if they would be interested in hearing, revisiting Mr. Keith's case. And so currently, Mr. Keith has a lawyer in Cuyahoga County who's working with him now. But that's just an example, and working diligently because of a number of reasons why it needs to get back in front of either a judge or back in front of the governor, because his brother, again, still maintains his innocence, but sitting currently now for a life sentence. Being here today is important. I didn't think about, so I see down on my wrist, I have this Holy Cross band on. I told you, Jesuit Holy Cross, I got a boat flowing through me. But this is the theme for St. Ed's this year. It's a courage to act. And I thought, well, I'm here. My daughter, I could be at home with my family. My son's coming home from college tomorrow. My wife wanted to have a little surprise for him, and we're buying him a queen-size bed because he hasn't had a bed since he's been away in college, and all this fun stuff. But I'm here, and I told her that'll wait till I get home at 10 o'clock tonight. And as I was listening to the judge talk, I looked down at my wrist and thought, the courage to act. And so that's why we're here. If we can answer questions, we will answer as much as we can, or as openly as we can. We thank you for coming out tonight. The process was a good process. It was a process that brought out 56 recommendations. There are some who are moving forward with those recommendations, but a lot have not even been addressed, or the legislature has not even had the opportunity to look at for a lot of other reasons. So, that being said, the judge and I will take questions, or if you want to ask.
Now, are there any questions that anybody has?
I have to get in view of this camera.
Okay.
So we'll have to sit here
Okay.
and put my arm around.
All right.
So did the was one of the ideas out of the task force that this would be used as a blueprint for advocacy? As a tool for advocacy?
I think what the chief wanted was, it was sponsored by the chief of the Ohio State Bar Association. Our Chief Justice commissioned us. And the hope was that when we were done with it, it would be presented to the governor and to the state legislator, both the House and the Senate, with that hope. And so that's, once it was finished, the recommendations were published in last April. We're coming on a year now, where they've been in the hands of those individuals.
We are not going to have any executions in 2015, is that correct?
That is correct.
Now, that can work for or against us, because, it gets put on the back burner. We're not going to have any executions. It would seem to me it would be a time, kind of a great time, to really do something about this so that we can get rid of it. Of course, most of us in this room would like it to be gone.
Yeah.
But
You want to speak to that, Abe? Well,
If I may.
come on up.
My name's Abe Bonowitz, I work
Look
for
into that
Ohioans
camera.
to Stop Executions. And in fact, there is things happening that I'm surprised Judge Russo didn't mention. In fact, he has helped organize the 8 judges who are on the task force to work within the Judicial Commission, is that what it's called? Some of the recommendations must be legislated. Others are rules changes that have to go through the Judicial Commission to change the rules. And they're working on those. But the rest have to be legislated. And in fact, so far 4 have been enacted. Now, he mentioned you can see this report on the website of the State Supreme Court. If you go to Ohioans to Stop Executions website, OTSE.org, you'll find a searchable database. You can search by number of topics and it'll pull up the recommendations within whatever that topic is. And also there's an indicator of which ones have been passed so far. So you have that. The work that's being done, and can we pass out, people, can you help us make sure everybody gets one of these cards? We've got to give everybody one of these cards. It's actually 4 pieces of paper. Don't pull it apart. There's 3 postcards, one to the governor, one to your state representative, one to your state senator. And the request is that you fill these out and leave them with us so that we can stack them up and deliver them at an appropriate time. The last piece on the side is if you would like to get on our list to keep you up to date with what's happening, then fill out this part also. And you'll note that actually we're the only state that does this. You can check, I am against the death penalty, but if we're going to have the death penalty, let's make sure it's fair and accurate. And you can also check, I support the death penalty, but I want to make sure it's fair and accurate, right? And that's the thing that is really important to keep in mind here. By the way, there's also this piece of paper which is on the table here, which has on one side information about the task force, and on the other side, it has some information about the fairness in Ohio's death penalty. I'd encourage you to take that with you. This task force was about fairness and accuracy. And with that, I've also been asked to introduce a couple people that are here with us, and I'm glad that I want to acknowledge Charles Keith is not only somebody who's got a brother on death row, he's also got a brother who was lost to murder, and he's also on the board of directors of Ohioans to Stop Executions. That's Charles in the back there. And behind him are 2 men who, until November and December of this past year, were convicted of murder. One of them is the exoneree in this country who spent the most time in prison. And both of them went to death row. And I want to invite Ricky to come up and share a few minutes, if you would. Just a little bit about that experience and what you're doing now. And Kwame, if you'd like to as well, at least come up and stand with Ricky. There's a 3rd man that was a part of this group. They were all boys at the time of the crime in Cleveland in 1975, was it?
Yes, correct.
You know, they're not going to present a long story. We weren't expecting to do this. They were right at the last moment. But these men survived time on Ohio's death row and decades in prison for a crime they had nothing to do with. And that's what this task force is about. And that's why here in Ohio we have to enact these regulations, so that, or these reforms, so that we don't do this again to anybody.
Thank you for having us. My name is Ricky Jackson, and as the gentleman just stated, I have the dubious distinction of being the longest serving, having served the longest time for being an innocent person in prison, 39 years. I was released November the 21st of this year. I spent 2.5 years of those 39 years on death row, along with 2 of my best friends for crimes we did not commit. As you may well know, we were later exonerated. I think that I wouldn't say that our case particularly typifies why the death penalty is so wrong, but 3 innocent young men lost their futures and almost their lives based on absolutely nothing but hearsay. It was, I don't know if it was fate or God or whatever, but we came so close to dying, and things just turned out, it was fortunate for us that things turned out the way they did, and we're here today, and that's pretty much all I have to say about that, unless anybody has any questions for me.
I do.
Yes.
When you were sitting on death row, what did you do every day? Pray
You have to be very creative. You know, you do. We created chess boards. We made chess boards. We made our own cards when necessary. I mean, you had to have a vivid imagination, you know, to stay sane back there, because in 1975, death row was a pretty barbaric place, you know, way below the standards that they have now. And, you know, we were not allowed access to the fresh air, outside, sunlight, out of your cell 2 hours a week, you know, and the conditions back there were horrible, you know. Today, if you did that to an animal, you would be arrested. You know, your face would be plastered on TV. You would be arrested as a terrible human being. But you know, that's the conditions we lived in for almost 3 years.
Then how did you get off death row?
In my case particularly, there was an error with the sentencing phase of my trial, and so they deemed it worthy of having my sentence commuted to life in prison. But for the rest of the gentlemen back there, at the time we were back there, the Ohio death penalty was in flux as to what they wanted to do. And so fortunately, it worked out well for the guys that were back there on death row naturally. And, but you know, needless to say, they're back in full swing now. Yes.
Question. Doesn't the use of a death penalty specification work specifically against innocent defendants? Because if you're innocent, are you going to want to take a plea deal and say that you're guilty?
But as Your Honor stated earlier, that's what the whole plea deal is designed.
Exactly.
Precisely that, to put upon the defendant so much that, I mean, what extreme is there than other than losing your life? I mean, you know, there's no, you know, and so, I mean, I could understand someone being innocent, but with the specter of death hanging over your head, I mean, really, what choice do you have?
Yeah.
You know, it was just a testament to my two friends and myself that we were determined to see this thing through to the end, no matter how it turned out. We knew we were innocent, and we were determined to fight till the end. But, you know, I don't blame anyone, because, you know, we really rolled the dice all the way through. I mean, you know, really it was a crapshoot. And it could have easily went the other way for us, you know. Yes.
Ricky, and what's your name?
Kwame.
Kwame? I'm just like marveling at the fact it's been 3 months, right? You've been free for 3 months.
Well,
I don't know, I'm like speechless at just the thought of that, like most of your life being spent in prison. What's it been like for the last 3 months?
oh, the last 3 months have been great. I mean, I can't say much for the last 39. The last 3 months have been, you know, absolutely spectacular. You know, I feel like I've been out longer than 3 months. I met a lot of really nice people. You know, I mean, and I've gotten a lot of help from people I would have never thought of. You know, and so it's really been great. You know, we are still going through an adjustment process, at least I am, you know, it's, you know, I guess I seem normal, but I have a lot of things and issues that I have to address and, you know, work out. Yes, sir.
You know, it shows that hope is alive. You know, it shows that there's opportunity, because I'm in that same battle.
Exactly.
And seeing you guys stand there, it gives me a lot of hope. But I tell people, and I say it in a sarcastic way, that I wasn't educated by Ohio State, but I was educated by the state of Ohio. And that is a heck of a education. It's like being thrown into water, you sink or swim.
Exactly.
So if you
And
swim, you're there, you can swim with the best. But if you drown, there's no more discussion.
I'm sure that as far as defending a death penalty case today is concerned, it's gotten a lot better. But in 1975, it was pretty much like defending a car theft case, you know, and that's how they treated it, you know. I mean, with the amount of evidence they had, I will never, to this day, understand how a grand jury could indict anybody based on, especially you talking about 3 human beings and you're talking about the death penalty. Please bring me more. Bring me something.
How old were you?
I was 17. Well, I was 18. I just had my 17th birthday. We got arrested in May. I had a birthday in February, so I was 17 years and a couple of months. My friend here, he was 17, and his older brother was just 20.
What was the evidence that they used to convict?
Hearsay. Well, they had a supposed eyewitness, but it was obvious to anyone with any kind of sense, especially the so-called quote-unquote professionals that were involved in the case, that this was a complete fabrication from the very beginning. And it's like I said, it still boggles my mind that a grand jury could, you know, just throw our lives, cast our lives into the winds like that based on that evidence.
Specifically, was he 13 years old?
It was a 13-year-old child at the time, yes.
And he was coerced by the police, told if he does not testify against these boys, that his family would be imprisoned. And you know, and it took him a long time, and he's still suffering too. It took him a long time to come forward, and it took a lot of people talking to him to get him to come forward. And then it was still several years of process before these men were released. And that's the thing about these task force reforms. There's a number of them, and if they were in place today, this could never happen to people. Which is why it's so important that we contact our legislators, we fill out these cards and leave them with us, that we bring people back to talk more to the whole church, that you all take this message, what you've heard, forward and share it with people. This video is going to be on our website in a few days. There's already just now there's a video. Thank you both. There's a video called by, was it Fusion? Fusion Network that just came out. It's about 16 minutes. It really tells the story. So there's a lot of information out there, and we have to carry it forward and share it with people. So I want to make sure these guys get back up to finish their questions. But Kwame has something he wants to say, and I think we can hang out as long as people would like to chat once we break. So.
Thank you guys for having me. I was originally Ronnie Patrick Bridgman, and my brother's Wiley Bridgman. Then you just spoke with Ricky Jackson. We were tried, convicted, and sentenced to death in 1975. As he said, we were both 17 years old, and of that mentality. I say that because I smiled when I heard Mr. Keefe say that he was not educated in the state, but by the state. And I feel the same way, because we were just children, you know. And I still actually believed in Thanksgiving and Easter and all these things. And I had to grow apart from those things that I knew as a child who were unaffected by these type of social and emotional molestations. My life will never be the same, as will Ricky's or my brother. This is an atrocity that happened to us. It's happened thousands upon thousands of times, day in and day out. These matters are human matters. They're not so much social, they're human. These are things that happen to real people who breathe, who live and die. Ronnie Bridgman died on death row, and Kwame Ajamu came from that fire. These were very, very, very strenuous and hard times and moments for us. We were, again, kids sentenced to die for an element that we had absolutely no knowledge of, let alone any participation in. During the course of my death row tender is when I became grown, so to speak. At 18 years old, I stopped being a child and stepped into the grown man situation. My life was threatened, as was my two brothers. We had to have some type of hope. We had none. We had to have some type of help. We had none. The legal representation that we had was, I thought it was better than the lawyer I had. We had none. And so we were stuck. I want to touch briefly when you asked Ricky about leaving death row. It was in 1978 that the Supreme Court ruled that the Ohio death penalty was unconstitutional. Had that not happened, this conversation probably wouldn't be here. And so we were twice sentenced, I like to say, because after the death penalty had become null and void in the state of Ohio, they resentenced us to life. And again, I'm coming from being a child who's learning now, man, I'm on death row, I'm getting ready to die, and now you ain't gonna kill me, but you're gonna keep me here forever. So these things kind of, weighed heavy on my mind, and so I began to grind. Once we got off of death row because of this legal action that happened in 1978, a whole nother world came upon us. And this was being incarcerated in Ohio's maximum security institution. We were boys. The oldest person, or should I say the youngest man in Lucasville at that particular time was 33 and a half years old. We were about 18. So our journey has been one that is both bumpy and full of thanksgiving and graciousness because of people like you, people who chose to listen and believe, and who had the courage to stand forward and let's try to make something happen with this. So I say today, before leaving you, as I've said in the courtroom with my exoneration, and I will say forever, if we can stand to fight just one battle and win against these atrocities, we did a good stand. We had a good fight. I'm so pleased to actually look at judges in a different light. Hey, in a different light. I'm so pleased to even be standing here and say these things, because had it not been for that ruling in 1978, probably be a different story.
Have you ever gotten in touch with the victims' families, or the victims' families ever tried to get hold of you?
This is, it's funny you would ask that.
Or are they not allowed to?
Oh, well, we actually growed up together.
Someone asked me that question yesterday, and
It's my sister. No, I'm just kidding. I'm just kidding.
and as much as I would probably like to, because I feel a deep remorse about, because they also were made a victim in this whole thing also, and for all these years, those people were going about their lives thinking that that was behind them when it really wasn't. The officials in Cuyahoga County, so that family, his family, my family, and everybody who was alive and in that particular community at that time, the citizens, the taxpayers, they sold everybody a bill of goods, and so nobody got justice out of this thing. Nobody, absolutely nobody. But back to your original question, I would personally like to meet with that family, just to share my understanding of what they're going through, because I was made a victim of the same foolishness also. But, that's really a touchy thing, because I haven't seen or heard any kind of contact with that family since the day I got sentenced and went to prison. And, it's hard to say how they feel about this whole ordeal. I hope they understand, and I hope they don't continue to hold us responsible, because they have the wrong people, obviously. We're not the people. We're not the ones. We're not murderers. We're not criminals. We're decent people who were put in a bad situation. But like I said, I would like to meet with that family, but I think it's highly unlikely that that will ever happen. But who knows? We're here, so anything is possible, Anything is possible.
Thank you.
Well, I'd just like to thank both of you for your words. Just amazing. And that's the third time I've heard from exonerees who have suffered an atrocity like these gentlemen have. And what strikes me is that they stand before you without anger, bitterness, and just gentlemen standing up and trying to help the system change and prevent what happened to them. This is really the ultimate injustice wrongful conviction. I always say to Judge Russo, you know, we're here for a limited period of time. John and I joined the bench in 2005. He's now the head judge of Cuyahoga County. And it seems like yesterday that we just started and we walked into our first judges meeting all nervous, and now we're at a point where, hey, we have to act now. The system can always be improved. You know, what these two gentlemen just testified to and their experience proves that the system is not infallible. We have to constantly be vigilant on ways we can improve process to make sure that this never happens again. You know, for the first time, when I was a prosecutor in 1992, I remember prosecutors getting before juries and talking about the strength of eyewitness testimony and how strong it is. Testimony that may have taken place months after the actual identity. They don't say that anymore because they know it's been scientifically proven not to be. I now have prosecutors in my room picking the juries now that DNA is in existence, and they're saying, hey, you know, they're telling the juries the exact opposite. Eyewitness testimony is the worst testimony you can rely on. We have DNA. Now it's totally switched. So what I would like to see happen, in addition to the reforms of the death penalty, individuals who make actual claims of innocence, once they go through the process, we have to come up with a faster process of bringing those claims back before the court. Many individuals file motions based on new evidence that languish on, it depends on the judge's docket that you get on. If the judge wants to rule on it, he'll rule on it. If not, it could languish for years. There's no spotlight or transparency on that process. We have to improve that so that claims of innocence. There's a myth out there amongst the public that everybody that goes through the system claims that they're innocent. It's not true. In 10 years on the bench, I've only had 2 people claim that they were innocent. And I brought them back. We had a hearing on the record. I had the prosecution go through the evidence. It took 10 minutes, 15 minutes, and it turns out that the claims weren't true in that case. Why can't we do that for everyone? So truly individuals who were innocent, like these 2 gentlemen, like Raymond Towler is at 29 years in prison, and they had a similar experience. You both came out of my courthouse where I work in. He had a similar experience with ineffective counsel, and if you listen to his story, he was charged with rape based solely on eyewitness testimony of 2 children in Rocky River. When he went to trial in his courtroom, the judge in that case actually forced him to come back into chambers without his attorney, told his attorney to stay outside. He told him to take a look out that window in the courthouse where I now work and said, take a good look at that city. If you don't take a plea in this case, you're never going to see that again. He said, I'm innocent. I'm not going to take a plea. He went to trial based solely on eyewitness testimony. He served 29 years of his life until finally the DNA was tested after years of litigation where the state didn't want it even tested. I mean, we have to come up with processes that improve this so that people that are convicted who are innocent can get back before court, provide that transparency, and I thank you for telling your story, because that's what's going to make things change. Appreciate it.
I don't know if there are any other questions. Sure.
In terms of priorities, did the Joint Task Force, of all the recommendations, prioritize them? Or are they all like, these are our recommendations without any priority?
Pretty much by section, the judicial section, you were on what?
Assigned counsel, and so it's not prioritized. We didn't look and say out of the 56, which one's more important. We did not. Yes?
Judge Donnelly raised the issue of prosecutors withholding information, especially exculpatory information. Are they allowed to do that?
No,
that's not legal.
No, it's not.
Okay.
And we have a new rule, Rule 16, which is a rule that has been revised recently about prosecutorial misconduct and turning over that information. But we're trying to, more of us now are saying on the record with the prosecutor, have you turned all that information over? Is there anything else exculpatory that we need to know about?
And that never took place years ago in the 80s and the 70s. They didn't have these discussions on the record where you force the prosecutor to say, did you turn it over? So when you didn't have a record of that, years later, when the defendants would claim, I never received that, the prosecutor would say, oh, yes, you did, but there was no proof. We turned over everything, and there was no record.
Okay.
What we're proposing in these rules, complete transparency. You have to list everything that you're going to use, everything that you turned over. If it's ever proven you're making a misrepresentation, you lose your license to practice law.
Right. I know way in the back you've had your
That was gonna be my question. At some point, are there any type of reprimands for the prosecutors and judges? Are they getting disbarred? Are they just getting a slap on the wrist? What's happening?
I mean, at this point, there hasn't been a lot of disciplinary actions brought against individuals. That they would have to rise to the level of purposely and purposefully withholding. I don't think anyone has gone to that length to say this person then purposely did this and they should have their license removed. So, but clearly it should be a punishment, as the judge says. The prosecutors have now started these integrity units, where they're supposed to now be looking at cases before they charge them, and if there's some question of concern, that they have these separate prosecutors who are looking at integrity to make sure that the case is one that should move forward. I agree with Judge Donnelly. I think there should be a post-trial or post-conviction integrity unit where claims such as innocence that are being made are looked at quickly, and somebody is looking at the integrity, and it's not the prosecutor, or maybe it's an independent body who's doing so. So we don't have 39 years in prison over something like this. Yes?
This might be an apples and oranges question, but I also work on the issue of human trafficking. And
Yes.
they had a study,
Yes.
like you did, at SAT. I'm really concerned about your comment about dust. But the current AG picked it up, and that's what I think got steam going with that, so that there is some things being done with that. So, like, just going to the legislators, do we need to go to the Attorney General? Is
Our
that-
Attorney General has it and aware of it. They had someone on the committee.
Okay, but they're not picking it up.
Not as of yet.
Yeah.
Yes?
Were there any exonerees on your task force?
No. No, there was not. Yes?
I'm a children's services caseworker, and I just wondered, the men and women who appear before you in your courts, how often do they have children's services backgrounds?
Where they've had
Interaction, yeah, involvement with children's services.
You mean the defendants who come before us?
Yeah, I want to say, I would say 100%, but I don't want to overstate it, but it's, just about everybody has some contact with.
Yeah.
Again, when you go back and with the sentencing judges, we have to look at that when we make when we look at a sentence, we look at all the evidence base that person brings to us. What kind of life did they have? Did they have a family? Did they have stability? Were they sexually assaulted? Did they have an education? Were they malnourished? So we get all that. So I would say the majority of those who are in front of us have gone through the Children's Family Services.
If you sit through a death penalty trial and then you hear the horrifics of the crime, that's why there's a mitigation phase. Because once you hear the mitigation, in some of these cases, it's so atrocious. These people have been raised no love, no caring, no nutrition,
abuse,
nothing but violence from day one. Then it's easy to understand what took place.
Yeah, Pete?
Can you provide clarity on the mental illness thing? I mean, I would speak from an ignorant standpoint. I thought the Supreme Court said we can't execute mentally ill people. But then there's a lot of that in the task force recommendation when there's still all these stories in the news where they're saying, well, this guy had an IQ of like 56 when he was 14, but he still gets executed. I mean, you guys provide clarity on
Well, I mean, it's constitutional, not permitted to execute someone that's mentally ill, but that's where the litigation will take place, whether they meet the standard, if they.
Yeah, there's a lot of different mental illness. I'm
Right.
psychiatric social
Right.
worker by trade.
It's there, but the issue is how do you get there and when do you say, yes, you are, and no, I'm not.
So your task force recommendation kind of touch that up.
Yes.
And the
A broader
law's
definition is what we.
Yeah, the
the law's
prosecutors were in favor
definition
of
of
that.
mentally ill and is so different than my training as a psychiatric
Correct.
social worker,
Yes.
is vastly different.
Yeah, there's an important distinction between mental, low IQ, mental retardation, developmental disability, and mental illness. Two different things.
Right.
Developmental disability is disallowed by the U.S. Supreme Court, whereas it's still, we execute people with mental illness all the time in this country.
Right.
Yes.
I just wondered if the family of the person that was murdered speaks on behalf of not executing the person, does that carry any weight?
So I haven't had that circumstance. I would
The family says,
Well,
we do not want this
if you look
person
at that
executed.
crime that I described in Knox County, that's what the prosecutor put forth as the reason of why they allowed that plea to take place. Victim's testimony is not supposed to control what the state advocates for in terms of the sentencing. Victim impact testimony from a victim is important to hear in delivering the sentence from a judge. We weigh that, the impact of the crime. But the victim's desires as to what the punishment should be should not guide what the court imposes. The law should. And
because you may find in one jurisdiction, should we follow what the victim's family says? So one is very angry, one isn't, one says don't, one says do. You have that inequity again.
Right. I mean, the key about understanding why the death penalty isn't applied equally over the state of Ohio is to recognize the fact that we have 88 counties, 88 prosecutors, 88 different philosophies. Some prosecutors don't believe in the death penalty, just like everybody in this room, are morally opposed to it and have gotten elected by saying they will never impose the death penalty. And should a heinous crime that would meet the criteria of shocking the conscience of everybody in the room, that defendant will not, should it happen in that county, will not receive the death penalty. All
right, we're going to get the...
One more question.